I want to welcome everyone who's on the line to our presentation today. My name is Bob Nichols with Bracewell. I'm a labor attorney who's been practicing for 31 years, and during that entire 31 years, a major concentration of my practice specifically has been occupational safety and health. I've handled countless OSHA cases. Unfortunately, I've been involved in quite a number of OSHA fatality investigations, including multiple fatality investigations. I've litigated OSHA citation cases before the Occupational Safety and Health Review Commission. So occupational safety and health work has been a big part of my life for a very long time. And I was struck with the emergence of the COVID crisis and pandemic this spring with how significant this was from an occupational safety and health perspective. And with me today is Caroline Melo, with whom I work at Bracewell. And we're going to talk about how employers have been impacted and the types of complaints that are being made to OSHA and how you try and avert being the subject of those complaints and how you effectively respond if you are the subject of one of those complaints. A couple of housekeeping matters. We're going to try and talk for an hour today and only an hour. We are approved for 1 hour of CLE for those of you who are attorneys. For those of you who are not attorneys but have other certifying organizations, we're glad to give you a certificate of completion, and we find very often other organizations will approve this program for an hour of continuing education. Finally, I want to note that in the upper right-hand corner of your screen, you will see a box for questions. My guess is we will not have time to address those questions during the call today. We have a full hour of material, but we will respond to any questions posed, Caroline and or I, by email or phone call without fail. So please do not hesitate to use that question box. We will get back to everyone who poses a question with a good and effective answer. With that said, let's move forward. I want to talk, to give you the broad brush today, about three things with Caroline. First of all, we want to talk about the innumerable complaints that have been made this spring to OSHA by employees alleging unsafe conditions in violation of the Occupational Safety and Health Act, the OSH Act, by employees. And we want to talk about how to avoid those complaints and how to put yourself in a position to win if you're the subject of such a complaint. Secondly, we want to talk about a unique phenomena that doesn't come up very often. It hasn't in my 31-year OSHA practice, but has come up quite a number of times during the last 3 months of our pandemic. And that is employees refusing to work. And you may think if an employee refuses to work or refuses to do a particular assignment, refuses to get on that flight internationally or to Seattle because they're afraid of COVID, you may think you can fire the employee. Well, that might be the case, but it's not that simple. We're going to talk about OSHA law with regard to refusals to work to perform a task, and what rights employees do have. Finally, we're going to talk broadly about OSHA retaliation claims. Section 11C of the Occupational Safety and Health Act prohibits employers from retaliating against any employee for raising any safety or health concern in any way. We're going to talk about how those claims arise. We're going to talk to you about how, again, to avoid being the subject of those complaints. And finally, how to respond effectively if you have the misfortune of being faced with a 11C retaliation complaint with OSHA. With that said, let's talk about how the agency has responded to this crisis and what they see as their role. First of all, OSHA is part of the Department of Labor. The Department of Labor is currently overseen by the Secretary of Labor, Eugene Scalia, a former management side labor lawyer and son of the former Supreme Court Justice. Mr. Scalia has faced a lot of criticism from labor unions and Democrats in Congress and others that OSHA has not been more vigorous in responding. In particular, the complaint is, why haven't there been more fines against meat packers and other employers who've done, in the view of the complaining parties, a less than stellar job on protecting their employees from COVID? Secretary Scalia has responded vigorously and has insisted that they have no higher priority in 2020, his agency, the Occupational Safety and Health Administration, than COVID-19 and protecting employees. He famously fired back to the head of the AFL-CIO, the cop is on the beat. OSHA is enforcing the law and requiring a safe workplace. And he went so far, I'm not sure this is always true, but he told Mr. Trumka, the head of the AFL-CIO, our OSHA guidance on COVID is not voluntary. Well, I think some of it is voluntary, but the point is if you don't do enough of it to provide a reasonably safe workplace, you can face a general duty clause violation. And in fact, Secretary Scalia has pointed out that the general duty clause of OSHA, of the Occupational Safety and Health Act that we will discuss, is the primary vehicle to punish employers who don't respond appropriately to COVID. But there are other OSHA-specific standards that might come into play, according to Secretary Scalia. An employer's poor reaction to the COVID crisis could lead to violations of the respiratory protection standard, the personal protective equipment standard, the HAZCOM, hazard communication standard, the sanitation standard, just to name a few. So Secretary Scalia says the cop is on the beat, OSHA is investigating and will punish employers for not properly responding to the COVID crisis in the workplace. Secretary Scalia reports that OSHA has conducted thousands of investigations into reports of unsafe working conditions. And in fact, government statistics show that during the short course of this COVID pandemic through May 25, OSHA or state plan agencies like Cal-OSHA have received a total of 14,808 complaints from employees about unsafe or unhealthy work conditions related to COVID, a really phenomenal number. By the way, they've also received lots of complaints, a separate kind of complaint, of retaliation by employees who say they were punished for raising concerns about COVID. Most of these safe workplace investigations, the 14,808, most of them that have been investigated have been what I call paper investigations. And that's for a couple of reasons. First of all, they don't have enough capacity, OSHA, to go investigate 14,800 plus matters. Secondly, like many of you, OSHA compliance officers by and large have been at home for the last 2 months, not in the field for safety and health reasons. So the paper investigations have involved OSHA receiving a complaint and sending a letter notifying the employer of the complaint and asking them within a few days to submit a written response explaining why the complaint is illegitimate, and if the complaint is legitimate, what abatement actions are they taking, and generally what the employer's done with respect to COVID mitigation. There's little indication that they find very many employers over COVID. I think in part that's because they just haven't had the bodies out in the field to be gathering firsthand evidence to issue citations. So they mostly have been warning employers through complaint letters that they need to be on the watch. As we're going to discuss, OSHA's modified its enforcement plan during this month, May, and as of this past Tuesday, May 26, compliance officers now in greater numbers are out in the field and purportedly are more of a position to conduct on-site traditional OSHA inspections related to COVID. And you don't want to be, as I put it, the low-hanging fruit, the employer who's done a poor job, who regards all of this as silliness and has not taken the necessary steps to protect your workers, because you could easily be the subject of a general duty clause citation, a substantial fine, and probably even worse, lots of bad internal and external publicity. By the way, in addition to these investigations, OSHA also has been issuing guidance significantly. They got a slow start compared to the CDC and the WHO, but they've issued lots of industry and other safety guidance related to COVID that we'll discuss to some extent today. Specifically, with regard to industries, OSHA has developed and released industry-specific guidance for manufacturing, construction, healthcare, retail operations, janitorial services, in-home repair services, emergency response, laboratories, business travel, meat and poultry processing, food and beverage. Some of these obviously relate to activities rather than industries. If you have employees who are engaged in business travel, certainly including international business travel, you should follow the guidance on how to conduct that travel. Also, if you have janitorial services or part of your business is retail, you should consider those specific areas of OSHA guidance. As I indicated, Secretary Scalia has cautioned that employers could easily face what's called a general duty clause violation citation if they don't react with proper vigor to protecting their workers from the pandemic. The general duty clause is found at Section 581 of the Occupational Safety and Health Act of 1970. The general duty clause requires employers to act reasonably to protect their employees from recognized hazards that could lead to death or serious bodily harm. So what are the specific elements of what I just described? If an employer fails to keep the workplace free of a recognized hazard, and it is a recognized hazard, and it is a hazard that could lead to death or serious physical harm, and there were feasible or useful methods to correct the hazard that the employer did not implement, you have yourself a 5A1 general duty clause violation. Let's talk about how these elements apply to COVID. First of all, often in general duty clause case litigation, a key issue is, was the hazard recognized? Well, with COVID, no one is going to argue that there wasn't a recognized hazard. And no one's going to argue that that wasn't a hazard that could lead to death or serious bodily harm. So the real key issue becomes simply whether the employer has taken appropriate, feasible means to mitigate the hazard. If you have done a poor job of responding to COVID, even if no employee ever gets sick, you very arguably have violated the general duty clause. Also has emphasized in guidance that it expects every employer to create and adopt what OSHA calls an infectious disease preparedness and response plan. Now that may concern some of you because you may say, Bob, we don't have anything called that. Well, you don't have to have a plan called that, but you should have written documentation as OSHA instructs that details what protective actions you've taken with respect to COVID-19. What steps have you taken? That should exist in writing. It should have been distributed to your employees. It may be more than one document, but through documentation, you should have decided and documented what you're doing to protect employees. You should have notified them of those protective measures. You should have trained them on those protective measures. That's what OSHA wants to see. Also, bear in mind, this is easy to forget. We're talking about your employees. You've got to also determine what you're going to do about other third parties who come on site. Many of you have done that. What are your rules for contractors, workers, visitors, and other third parties going to be? Remember, you can do all kinds of wonderful things for your employees, but when a third party comes on site, they are a vector for the disease like anyone else. They are a potential carrier. And if you haven't decided what to do about those visitors and contractors, you may undo all the good things you've done to try and protect your employees. By the way, people worry a lot, could I be sued by employees over my COVID mitigation efforts? Generally speaking, in most states not, because of such things as the workers' comp bar. Employees generally can bring a workers' comp claim, whether it be compensable or not compensable if they're hurt at work. They usually can't bring negligence suits. But guess what? Third parties can. So you better be careful about protecting contractors and their workers and third parties, because that can lead to tort negligence litigation if you do a poor job and someone gets hurt as a result of COVID. Notably, OSHA has identified a variety of mitigation measures in guidance starting in March and continuing through May that you can utilize to help protect your employees. Many of them early on came right out of CDC guidance because CDC was simply way ahead of OSHA on this pandemic in March and April. Obviously, hand washing is something that both OSHA and the CDC emphasize. You know all the rules. You've heard about 20 seconds and don't forget those thumbs, etc. They also want you to educate your employees not only on hand washing, but respiratory etiquette. Hopefully you've taught them all about not cough into their hands, etc. Hopefully you have stations throughout your facilities with appropriate supplies, given the fact we're living through a pandemic, that you have stations with readily available hand sanitizer with 60+% alcohol, that you have disinfectant for your employees to clean their work areas, that you have paper towels for them to use, that you have proper touch-free trash receptacles. OSHA wants to see all of those things, and they want you to educate, train your employees on all your mitigation efforts. OSHA emphasizes cleaning, obviously, as a major way of mitigating the COVID risk. Not only do they want your cleaning service to carefully and thoroughly clean and probably do more cleaning than you normally do, they want you to make sure you're using EPA recommended cleaning agents and that you follow the instructions. Sometimes with cleaning agents you use, you might have to have SDS's safety data sheets available for employees if they ask about what cleaning agents you are using. OSHA in their guidance emphasizes that you should think about what we call engineering controls, what you can change about your infrastructure, your equipment, your buildings to protect employees. They suggest that you install high efficiency air filters if you haven't, that you consider ventilation rates. Can they be changed, increased to improve the quality of the air? They want you to think about installing physical barriers where appropriate, for example, between employees and customers where they're close, or between employees and employees where they're close. For example, have you considered whether certain cubicles would be safer if they were outfitted with sneeze guards in between the employees? OSHA wants you to consider administrative controls. Are you training employees that not only is it a matter of them being infected, but if they're even symptomatic, if they have the dry cough, if they have the fever, are you telling them to go home, and if they're at home, not to come to work? Have you replaced your in-person meetings to the extent you can with telephone and video conferences? Have you, I assume you've done this, but I hope you've discontinued, if not all business travel, all non-essential business travel. Are you conducting not just one-time training with your employees about your mitigation measures and what you expect of them, but are you periodically reminding them of their expectations for employees to protect themselves and their coworkers? Have you looked at shifts? Are there changes you can make, for example, staggering work shifts so there's lower exposure among employees? Again, touch-free trash cans, disposable towels, sanitizer. And do you actually post your hand washing instructions in your restroom? Many of my clients, and by the way, at my law firm, in every restroom has instructions on how to wash your hands posted. Many of you have done that. You all should do that. OSHA, in explaining what employers have done, has created what they call a risk pyramid, and they expect employees, or employers of employees, I should say, higher on the pyramid to go even further in terms of mitigation efforts than those with employees only lower on the pyramid. They created 4 categories for this pyramid: very high-risk occupations, high-risk occupations, medium-risk occupations, and lower-risk occupations. They look at such things as industry type and whether the particular job position will require someone to be within 6 feet of other people. And they came up with these 4 categories and tried to explain what employees fall into what category. The very high exposure risk, which again, as the pyramid illustrates, involves a very small group of employees, is really mostly a subset of healthcare workers. Healthcare workers, for example, that perform aerosol generating procedures like intubation, dental care procedures, etc., are very high risk. Laboratory personnel who work with live specimens are high risk. More workers are high risk. You know, my wife, who for a long time earlier in her life was a registered nurse, and I talked about what intubation was, and she explained that, you know, the classic example is that nurse who places that tube down your throat. So if you ever ask why people talk so much about healthcare workers being brave, envision yourself tasked with putting a tube down the throat of a COVID patient, and the risk that poses for you as the healthcare worker. They certainly deserve our appreciation. In addition to very high exposure risk employees, we have high exposure risk employees. OSHA tells us that that involves healthcare delivery and support staff. So every healthcare worker who doesn't fall into the very high risk exposure category, such as those performing intubation, fall into the high exposure risk category, as do transport medical employees, such as ambulance drivers, and mortuary workers. It's interesting that mortuary workers are high exposure risk and morgue workers are classified as very high risk. The medium risk category now involves more people represented by some of the companies on the call today. Medium risk employees are employees who cannot regularly maintain the 6-foot distance from other folks. What would those people be? Well, certainly retail employees who have to work with customers are all medium risk. Meat packer workers, you can't run a meat packing plant and keep employees all 6 feet away. If you've ever seen one of those places, you would know that. Flight attendants, as we all know, cannot maintain 6 feet. Bus drivers can't maintain 6 feet. And employees traveling internationally can't maintain 6 feet. Those are good examples of medium risk employees. And it's a big group given the fact we're talking about retail. And then everyone else, that is people who can regularly maintain 6 feet plus distance between their coworkers and other third parties at work, are lower risk. That includes lots of us, particularly those that are lucky enough to have our own office or a cubicle we're not right on top of someone. I want to talk a little bit about the latest OSHA guidance and what it tells us about what you should be doing to prevent from being the subject of a complaint. On May 19, OSHA indicated that they expect there to be more complaints, not less, now that non-essential workers are returning to work. They've emphasized that, again, COVID-19, they tell us in their May 19 guidance, is their highest enforcement priority right now. By the way, for those of you concerned with who have to keep OSHA 300 logs under the record-keeping requirements of OSHA, OSHA on May 19 once again dramatically shifted its position on when you have to record or worry about recording COVID cases. Originally in March, they suggested there was a pretty broad duty among employers generally if they had an employee develop COVID to consider whether the case was work-related, and if it met one of the other general recording criteria like medical treatment beyond first aid, lost days of work, etc., then you had to record it. There was a lot of outcry about that, and OSHA backed off on April 10 and issued guidance that indicated that only certain industries that by its very nature created the risk for COVID infection, like healthcare, actually were required to do the work-related determination, perhaps record employee COVID cases. On May 19, OSHA swung back the other way and said, no, we're going back to our old position, and employees who have a COVID case that even conceivably might be work-related have to assess whether it in fact is work-related and have to also record it if it meets one of the general criteria. If it is work-related, it meets one of the general criteria for recording. Expect field visits in the coming months from OSHA. They were at home like you were, and like you, they're returning to work, and they may be knocking on your door, not just sending you a letter. Again, we are in an election year, and the administration is under intense pressure to show that they are committed to occupational safety by congressional, union, and other critics. By the way, be careful about some state occupational safety agencies that have unique or additional requirements, what they're allowed to have. Pennsylvania, New York, New Jersey, Michigan, they all have state safety and health requirements that go beyond what federal OSHA requires. Cal OSHA is probably the primary example of this. For example, Cal OSHA guidance instructs employers with regard to return to work, open quote, ensure employees who are out ill with a fever or acute respiratory symptoms do not return to work until both of the following occur, at least 3 full days pass with no fever, without any fever-reducing medications like aspirin, and no acute respiratory illness symptoms continuing, and at least 10 days have passed since the onset of symptoms. This goes farther than the CDC or federal OSHA recommend, and it shows you that you have to be concerned about state and local safety requirements in addition to federal OSHA. I want to turn now to Caroline to talk to you about some real nuts and bolts mitigation measures that, even though OSHA did not specifically raise them in their guidance, are things that lots of employers are doing, and that if you don't do, you automatically make yourself a target for someone who may not be doing enough under the general duty clause. Caroline?
Thanks, Bob. So as Bob said, there are several common mitigation practices that many large and responsible employers, many of the people listening to this phone call, are currently implementing in order to help protect workers from COVID-19. The irony, as Bob kind of hinted to, is that these recommendations actually come from the CDC. They don't come from OSHA, but implementing such practices will undoubtedly increase an employer's protection against being found to violate the general duty clause under the OSH Act. So the first practice we're going to take a look at is the use of masks in the workplace. So many employers are implementing policies requiring that employees wear masks in the workplace. I, for instance, had to wear a mask when I came up to the office today. Bob's had his mask on. And so many employers are saying, if you're in a common area, if you're in the hallway, if you're not in your office with a closed door, you need to have a mask on. And the CDC does recommend the use of face coverings, especially since COVID-19 can be so easily spread by people that are asymptomatic. And the CDC also emphasizes that masks are not to be used instead of social distancing. So social distancing continues to still be important and should not be something that is not used when masks are being used. And face coverings can be fashioned from household items such as bandanas or other fabrics. I have a few, masks made from some fun fabrics found around the house, and they do not need to be surgical masks or N95 respirators. The CDC actually recommends against the use of these later type of masks, as those need to be saved for our healthcare workers. And the CDC actually provides on its website some instructions for how to make a mask. This may be helpful for y'all to look at if you want to distribute to your employees that might be looking for ways to make masks from things around their house. Secondly, many employers are requiring that employees have their temperatures screened before entering the workplace. And it's important to note that temperature checks are not a practice that is normally allowed in the workplace. These are medical examinations and can really only be used when there is a quote-unquote direct threat as defined by the ADA. But recent EEOC guidance has provided that employers may take the temperatures of their employees before allowing them to enter the workplace. So again, this is probably not something that will continue, after the pandemic hopefully ends. And temperature checks are a practice that we're seeing many clients implement. Bob and I have reviewed tons of temperature check policies and different protocol that clients are drafting, which is great. And many clients are using this despite the fact that not all individuals with the virus will actually have a temperature. But we're seeing the fact that it will eliminate some cases from the workplace. That's obviously a positive. And then taking temperatures does seem to put employees at ease. But employers need to make sure that, they're not operating under this false sense of security, or that, employees think, if you don't have a fever that you for sure don't have COVID. So obviously something that, needs to be addressed there. And again, when you're developing these plans, you need to think about, who you're going to designate to take these temperatures or to screen them. Are they receiving the training that they should be receiving to do that? Do you have employees spaced out in line while you wait? Are you keeping medical information confidential? There's certain, it needs to be not contained with the personnel records. And are you isolating individuals immediately when they are found to have a high temperature? We're also seeing a lot of employees a lot of employers asking employees to take their temperature at home before coming to work. So that's kind of another option that we're seeing. So another example of something that would not normally be allowed in the workplace, so again, probably can't do this after COVID, are daily questionnaires. So I filled out a daily questionnaire this morning before I came into the office. I got it in my email, clicked on a link, and answered a few questions. And many of these surveys contain medical questions. So that's something that normally would not be allowed under the ADA, but the EEOC has again provided guidance that employers can inquire about symptoms associated with the novel coronavirus. Employers still need to ensure, however, that their questions comply with other laws. For example, GINA, that's a big one that you want to make sure that the wording of your questions still complies with that law. And daily questionnaires have become very common. They exist in various forms. Like I said, I filled out one today. It was kind of a, an online survey. But we've heard about some clients that are, creating apps that employees can go to on their phone and answer certain questions. And so there's people can get creative and kind of can figure out, the best and safest possible to do that and store that information. Some of the key questions that we're kind of seeing are, one, asking the employee if they're experiencing any symptoms associated with the coronavirus, and then listing out those symptoms. So saying, are you experiencing a cough, a sore throat, a fever, shortness of breath, muscle pain, headache, loss of taste or smell, etc. There's a long list, but listing those out is helpful. And then a really important question is asking, have you had close contact with a person who is confirmed or suspected of having COVID-19 in the past 14 days? So as I mentioned, GINA is kind of an obstacle here, and you want to make sure that you're not asking an employee whether someone in their family has had COVID-19 or someone in their household. So this kind of gets around that and, offers kind of that blanket question of asking, have you had any exposure at all? And lastly, the CDC also provides guidance on returning infected and exposed employees to work. And many employers have decided to follow this as well. And again, this is guidance offered by the CDC, but that OSHA is going to be paying attention to when determining whether an employer, is protecting their employees and uploading their duty under the General Duty Clause. So for infected employees, we're seeing two different strategies that the CDC is provided for. One is a symptoms-based strategy, and two is a test-based strategy. And I think we'll see a shift between these, as tests become more available. I think we've been seeing more of a symptoms-based strategy. We may see a swing back more towards tests as they become more available and hopefully more reliable. But for a symptoms-based strategy, an employee should be excluded from the workplace until at least 3 days have passed since recovery, which is defined as a resolution of fever without the use of reducing fever medication like Tylenol or something like that, and improvement in respiratory symptoms, and at least 10 days have passed since symptoms first appeared. For the test-based strategy, the employee should be excluded from the workplace until there is a resolution of fever, again, without using fever-reducing medication. There is improvement in respiratory symptoms, and the employee has negative results from at least 2 FDA COVID-19 tests. Again, that was something that was very hard to come by at first, but I think we'll see more employers requiring that.
Now for exposed employees. The CDC provides that potentially exposed employees may be permitted to continue to work following potential exposure to COVID-19, provided, though, that they remain asymptomatic and additional precautions are implemented to protect them and the community. So potential exposure means a household contact or having close contact within 6 feet of an individual with confirmed or suspected COVID-19. And the time frame for that is around 48 hours, or it can be in the 48 hours before the person is symptomatic. These additional precautions that you need to be doing for these exposed employees include pre-screening, regular health monitoring, wearing a mask, social distancing, disinfecting and cleaning workspaces. All things that you should probably be doing for all employees. And if this exposed employee becomes sick, he or she should be sent home immediately, and other employees need to be told of their exposure to this employee. And one thing to kind of note about this exposed employee guidance is that it was very much formulated with the thought that we want to put employees back into the workplace as fast as possible, especially for these essential industries. So, employers listening out there, if you maybe are not as much of an essential industry that our community is relying on, you may want to think, let's keep this exposed employee out of the workplace for a little bit longer.
And again, I want to stress that while these recommendations largely come from the CDC, they're not from OSHA. Whether or not these recommendations are implemented by employers such as yourselves will likely contribute to whether a violation of the General Duty Clause is found down the road by OSHA. As more employers implement these recommendations and guidelines, employers who don't implement them will be seen as unreasonable and will not be seen to be taking the reasonable steps to protect their employees from hazards in the workplace under the General Duty Clause of the OSHA Act. So now that we have an understanding of several more practices employees can be doing to help protect their liability and their workers, I'm going to turn it back to Bob, who's going to discuss how to avoid complaints to OSHA.
All right, now comes the practical stuff. After 31 years and many responses to OSHA complaint letters, what are my thoughts about how you avoid being the subject of a complaint by an employee that your COVID-19 conditions are unsafe? First of all, if you have a strong mitigation program, as many of the employers represented on this call have, and you enforce it company-wide, the chances of you being cited by OSHA are de minimis. Probably the biggest risk for many of you is having a department head or a plant manager who does not take this process seriously, who is dismissive of COVID concerns, and thereby makes you a target for OSHA. Bear in mind, there's no worse scenario than to have a written document saying, these are the things we're going to do to protect infection of our employees by COVID, and then have someone in the organization fail to abide by or require their employees to abide by those procedures. A plant manager who's dismissive of masks, who's dismissive of questionnaires, who's not diligent about the cleaning and all the other steps we take. That is your nightmare scenario. You spell out, do A, B, and C, and they skip A and B. So you've got to both talk the talk, have the written documentation showing all your mitigation efforts, and walk the walk. Make sure everyone throughout your organization takes it seriously and respond vigorously when it doesn't happen. I've been in facilities since this crisis arose, and I'm struck by employees often, I think inadvertently, who suddenly find themselves bunching up 3 or 4 of them in a plant relatively close to each other. And I'm telling you, if I was a first-line supervisor or manager, that'd be a magnet for me, and I'd get over there and tell them not to do it. That's your job, to protect your employees from this COVID pandemic. You want to maintain several avenues for employees to complain internally. Many of you have toll-free numbers. You should never simply tell employees they have to report any concerns simply to their supervisor and no one else. The more avenues they provide, the better you look, and the more likely they'll actually use them and complain internally rather than going to OSHA. Encourage employees to raise concerns. You want to remedy them, not just because you don't want an OSHA complaint, but because you care about nothing more highly than the safety and health of your employees. Train your supervisors to be receptive to any concern raised about safety or health, even if the supervisor thinks it's silly. And when employees raise safety and health concerns, those concerns should be reported to EHS and very often should be reported to HR as well. They both have roles in responding. As painful as this may be in some instances, you should always thank employees when they raise their health or safety concern. After all, I can tell you from lots of experience, no one knows better about where the deficiencies lie with safety and health than line workers. Engage in an interactive dialogue once an employee's raised a concern. Don't simply thank them. Continue to talk to them, ask for their recommendations on what can be done, and circle back with them when you've decided on a course of action, and thank them one more time. You want them to talk to you and not to OSHA. You want to provide immediate response and protection for your employees. To be ready to effectively respond, also plan ahead. Oral discussions with employees about what you expect in terms of mitigation without any written backup is unacceptable. You can't attach an oral discussion you had to a response to a complaint letter. You want to have communications to employees, reiterating what you want them to do. You're going to want to have postings. For training, you're going to want to have attendance rosters, and you're going to want to be able to provide those to OSHA. They're impressed by those things if they're attached to a response to a complaint letter. Take photos of your postings, send employees reminders periodically of their role in mitigation efforts. Extend your mitigation efforts to contractors and everyone else on present. It's easy as a plant to forget those workers who don't get their paycheck from you or someone else. Again, they're vectors, they're potential sources of infection, just like everyone else. And they're also potential claimants against you if they get sick because of your less than adequate measures. Again, make sure everyone, including your first line supervisors, know they are expected to take this process of mitigation seriously. So you've done everything we've asked you to do and you still get an OSHA complaint letter. How do you respond? Well, you're going to have to write a letter, unless you're unfortunate enough to have them come on site. And again, which they're simply not going to have the resources to do in most circumstances. If OSHA sends you a letter saying there's been a complaint and they want you to respond to that health and safety concern, you start with a letter that emphasizes that your company has no higher obligation than occupational safety and health, along with perhaps environmental stewardship. That sounds corny perhaps to some of you, but you know, OSHA wants to hear that you've gotten the message and you're a believer. If you have good things to talk about with your company, a good safety record, safety awards or accolades, a substantial financial investment in EHS staff, et cetera, tout those positive things early on in your letter after you talk about your commitment to safety and health. One thing OSHA is trying to measure up when they read these letters, am I dealing with a good actor or a bad actor? You want them to let them know your organization is a good actor. Thank OSHA in the letter early on for bringing the concern to your attention. After all, you want to know about safety and health concerns. Explain that you promptly immediately investigated when you received their notice of a complaint of a safety or health concern. Explain why your COVID-19 mitigation program is exemplary. Laundry list all the things you do. Attach supporting papers like policies and emails you've promulgated, photographs of postings of hand washing instructions, etc. And while you need to explain why you have an exemplary program, I have found through writing many of these letters, it's always good to offer OSHA something more. Tell them that while you have an outstanding program, to further emphasize our commitment to X, Y, and Z, we are going to conduct retraining in this department or this facility or company-wide on these issues. OSHA loves that. Their supervisors love that. Again, that shows to them you've gotten the message in your good actors. You should always have external or internal legal counsel review these letters. Response to an OSHA complaint is an important legal document, and if you make a damaging admission inadvertently, you can be hurting the company's position going forward. Legal vetting of your response letter is essential. I'm going to turn now back to Caroline to talk about refusals to work and how you deal with them. Caroline?
Thanks, Bob. So now we'll be addressing the question of whether an employee can refuse to work out of fear of contracting COVID-19 in the workplace. So of course, you know, everyone's favorite legal answer, it depends. It's going to depend on, you know, why are they refusing to work? Is it out of, you know, because of an unsafe condition, a underlying medical condition? Are they just fearful? What is the issue here? So we're going to answer this question by looking at several different areas of the law. We'll first look at the OSH Act, or the Occupational Safety and Health Act. We'll then look at the Americans with Disabilities Act, or the ADA, then the National Labor Relations Act, or the NLRA, and then we'll take some time talking about some state laws and how that may affect your responsibilities under OSHA. So getting first to the OSH Act and its enforcement by OSHA, OSHA encourages employees to bring unsafe or unhealthful working conditions to the attention of their employer. We want employees to come to employers and tell them why they feel unsafe. This gives you a chance to remedy it yourself. The employee, however, may also file a complaint with OSHA concerning a hazardous working condition at any time. But employees are not encouraged by OSHA to leave a work site just because they have filed a complaint. And under the federal regulations, employees generally have no legal right to walk off the job or refuse to perform work entirely. Employees are entitled, however, to refuse to work if they believe they are in imminent danger. And Section 13 of the OSH Act defines imminent danger for us, and it defines it to include any conditions or practices in any place of employment which are such that a danger exists which can reasonably be expected to cause death or serious physical harm immediately or before the imminence of such danger can be eliminated through the enforcement procedures provided by the Act. The key principle here is imminent, meaning there's not enough time for OSHA to come investigate. And when an employee refuses to work because they believe they're in imminent danger, there are certain conditions that need to be present. So, an employee can't just refuse to work at any time because they think something's unsafe. There are these 4 conditions. So if an employee comes to you, these are kind of the main things you're going to want to look at. So the first condition, where possible, the employee has asked the employer to eliminate the danger, but the employer failed to do so. Second, the employee refused to work in good faith. So this means that the employee must genuinely and actually believe that they're in imminent danger. They can't just be, kind of making it up. Third, a reasonable person would agree that there is a real danger of death or serious injury. And this is something that, should help the employer in some of these situations, especially if you are implementing a lot of these mitigation procedures that both Bob and I have been talking about throughout this webinar. And then fourth, there isn't enough time due to the urgency of the hazard to get it corrected through regular enforcement channels, such as requesting an OSHA inspection. And the Supreme Court in Whirlpool Court v. Marshall, this was a 1980 case, provided a little bit of guidance here of, what does this actually mean? Does the employee need to call OSHA? Do they need to request an inspection? What does that look like here? So basically, the court said that it's not an absolute requirement that a complainant call federal or state OSHA after being instructed to perform a dangerous task, but complaints have been dismissed when someone did not call OSHA. So generally, OSHA kind of looks to see if, one, the complainant called federal or state OSHA, and if they did not, whether there was a period of time which the complainant reasonably could have contacted federal or state OSHA but declined to do so. Basically, when an employee is concerned about a hazardous working condition, OSHA encourages them to do a few different things. One is ask the employer to correct the hazard or to assign other work. And honestly, that's what we want them to do. We want them to come to the employer. We want them to ask for this hazard to be remedied. And hopefully, each one of you here would remedy that hazard if they could. Second, they ask the employee to tell the employer that you will not perform work unless until the hazard is corrected. And they ask the employee to remain on the work site until ordered to leave by the employer. So again, OSHA does not encourage employees to just refuse to work and then walk off the site. That's not something that they want people to do. So how does this apply to COVID-19 and the novel coronavirus? So as Bob mentioned, I'm not going to get back into it too much, but under the General Duty Clause of the OSH Act, employers are required to furnish to each worker employment in a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm. So applied in the context of COVID-19, this means that employers are required to furnish a place that is free from COVID-19, which may not be possible, or as free as possible from COVID-19 as it can be. And hopefully most employers are adhering to their obligation. I think a lot of our clients are formulating these protocols. They are requiring people to wear masks. They are doing social distancing. So, I'm at least under the impression that a lot of employers are really working hard to make their environments hazard-free. But employees may still be concerned. They may still not feel comfortable. And honestly, these are very uncertain times. But under the OSH Act, if an employee in good faith believes that their employer has not taken appropriate steps or that their place of employment is not free of such hazards or to the most extent possible, an employee could refuse to work and would be protected from such repercussions. So for example, requiring that an employee work in a medical setting without personal protective gear, that may create an environment that could trigger imminent danger and an employee could refuse to work. Again, all these 4 conditions need to be met. The employee can't just, simply refuse it. So you need to look at those 4 things. And employers should really put themselves in the best position possible to respond to this. They should, correct these dangers, follow CDC and OSHA guidance, and that will really help kind of especially meet condition 3, where it says, a reasonable person needs to understand that this is dangerous. So how should an employer respond if one of their employees refuses to perform work out of the fear of contracting COVID-19 in the workplace? First of all, do not follow what this picture says on the screen. Do not act like this guy in the red shirt. That's not what we want. First, the employer should work to eliminate the danger. So like I mentioned, try to make your environment as hazard-free as possible. Second, the employer should listen to the employee and try to understand their fear. This is a lot of what Bob has already mentioned. Listen to the employee. Try to understand why they are fearful. Thank them for bringing this hazard to your attention. These are uncertain times, and many employees, regardless of the amount of precautions taken, are going to feel unsafe coming to work, or they're going to be scared. And honestly, we don't even know if a lot of these precautions work. So, if an employee comes to you, I think it's really helpful to say, how can I help you? What can I do to make you feel more comfortable? But if an employee answers that question and says, I'm scared to come to work because I have lung disease or I'm diabetic, then you're going into a whole different ballgame. And that's where you need to send the employee to HR to have that conversation. So under the ADA, what should you do if an employee refuses to work because of an underlying medical condition? So the CDC has identified certain medical conditions that make individuals more high risk of death or serious complications because of COVID-19. So I'm not going to, list all of them here, but chronic lung disease, diabetes, obesity, or really anything that makes an individual immunocompromised could place a person in a high-risk category. And a lot of these are conditions that, an employee maybe wouldn't have asked for an accommodation prior to the pandemic for this. Someone with asthma probably didn't think, I need an accommodation when I'm coming into the workplace. So you're going to see a lot of new employees asking for accommodations and being in high-risk categories that you weren't aware of. If an employee approaches you, the employer, and says that they have an accommodation, or that they need an accommodation, the employer must engage in the interactive process. And the employer must grant the accommodation as long as it is reasonable and does not create an undue hardship on the employer. And I'm not going to get into all the weeds of this, but the EEOC has also provided that this analysis of an undue hardship can be looked at under these new and present circumstances. So some employers do not have as much of the economic ability or the access to certain materials that they maybe had in the past. Again, also the EEOC has provided that you can shorten this interactive process a little bit, maybe don't ask for medical documentation, but you also want to make sure that any accommodation that you grant for an underlying medical condition is put in writing. And it might be something that's temporary and only during a pandemic, and you also want to put that in writing. But also note that, mere fear is not going to be something that's going to warrant an accommodation. Someone may, though, have a mental condition that may be exacerbated by the pandemic, and that needs to be looked at as well. So moving from the ADA, we're next going to look at how the National Labor Relations Act may play into potential legal issues when an employee or a group of employees refuses to work out of fear for contracting COVID-19 in the workplace. So Section 7 of the NLRA extends protection in both a union and non-union setting. So y'all employers out there that thought, I don't have a union, I'm fine with this. This is still something that you need to pay attention to. So the NLRA extends protection to employees who engage in protected, concerted activity for mutual aid or protection. So meaning circumstances in which two or more employees act together to improve terms and conditions, or even individuals that act expressly on behalf of other coworkers. So an employee may think that, they may be talking to other employees saying, we don't feel safe with these working conditions, and especially if it's employees working together, voicing these concerns, that's something that you definitely need to pay attention to. We're also seeing that unions are kind of using OSHA here as a way to put pressure on employers to follow CDC guidance or even go beyond those protections that OSHA is asking for. So I'm going to kind of turn it back over to Bob, and he is going to discuss how employers can avoid Section 11C retaliation claims under the OSH Act, because that's especially something that we want to avoid if an employee does refuse to work.
Thank you, Caroline. I want to talk about 11C before we wrap it up today. Section 11C, again, of the OSH Act prohibits discrimination, retaliation against employees for raising any kind of safety or health concern. Early on in the law, many argued that this complaint had to be made to OSHA to constitute protected activity. To make a long story short, the courts have rejected that view, and any complaint made by an employee internally within the company or externally can be protected. It doesn't need to be a written complaint. It can be oral. It doesn't need to be formal. It can be informal. Even reporting on-the-job illness has been found by OSHA to be enough to constitute protected complaint under 11C. One good thing for employers is the statute of limitations for an employee to bring a complaint with OSHA under 11C is only 30 days. If a timely complaint is made, OSHA will investigate. A compliance officer from their whistleblower task force will investigate. They'll ask the employer to submit a statement of position. It's very important because, as Caroline's going to talk about, the consequences of an adverse finding are really significant. This is not like the EEOC, where most position statements may not mean very much in the long term. The OSHA investigator, unlike the EEOC, will come out and interview witnesses live usually. They'll ask for documents. If the employer does not fully cooperate, they will issue a subpoena for documents or witnesses. You should prepare witnesses carefully before you allow them to be interviewed. Non-supervisory witnesses can be interviewed privately by the government. Supervisors, managers, EHS, and HR personnel, the company can have a lawyer present and must do so. The standard for deciding whether a case is meritorious is if the Department of Labor, OSHA, finds that there's reasonable cause to believe that the alleged adverse action, a discharge perhaps, a loss of pay, was motivated by some protected complaint by an employee about some health or safety concern. If they find reasonable cause, OSHA will try and get the employer to settle the case. Now you're in a much more difficult position. It's probably going to cost you more to successfully settle, but usually in that instance, employers settle, because if they don't, what their lawyer is going to tell them is the DOL will almost certainly file suit against you in federal court for violating 11C. And Caroline's going to talk to you about the very significant consequences if you lose an 11C case in court.
Thanks, Bob. So as Bob mentioned, OSHA may file suit against employers in federal district court at which they believe retaliation has occurred. And while many of these cases don't typically reach trial, the consequences can be significant. So these you want to avoid. You want to avoid going to trial here. Full damages, both actual and punitive, are available. Specifically, available damages include back pay and front pay, reinstatement, mental anguish damages, other compensatory damages, and punitive damages. And these damages are uncapped, so it can be pretty significant. And for example, if you look on the right side of the screen, we have some excerpts from a press release that shows where a federal judge ordered Lloyd Industries and its owner to pay $1.04 million to employees terminated for assisting in a safety investigation. And in addition to this extremely large amount of money that I'm sure no one would want to pay, a scathing Department of Labor press release was also published, and the whole public became apprised of the fact that this employer was retaliating against its employees for raising safety concerns. And the reason that many of these cases do not reach trial is that once OSHA investigates and finds a reasonable violation of the OSH Act, employers generally settle with OSHA. Sometimes these settlements are pretty large, though, but they're often better than what you're going to find in court. And the main point is that these verdicts are not very pretty, and you want to avoid Section 11C retaliation claims. I'm going to turn it back to Bob to discuss how to avoid such OSHA retaliation complaints and, if necessary, to win any claims brought against you.
Thank you, Caroline. I will say one other bad thing about those cases is if you lose, like happened with Lloyd Industries, the judge will often make you post a notice in the workplace informing employees about how you violated the rights of employees under the OSH Act. Okay, let's talk about how to avoid 11C claims, retaliation claims. Back to the practical stuff. You want to provide employees with multiple avenues to report concerns, whether they be safety concerns or concerns of retaliation. You should explicitly prohibit retaliation in your written policies. Many of our clients have it in their handbook, some have it in their safety manual. The better you off, the more you say it, because you want your people to understand, and you want to be able to tell OSHA if you get an 11C complaint, look, we prohibit this. We encourage employees to come forward. You need to train supervisors effectively about how to respond to safety and health concerns if you want to avoid 11C claims. Very often when we've had a difficult 11C claim, it's because of a siloing department manager, shift manager, plant manager who is dealing with a difficult situation on their own that an employee's raised about safety or health and failed to report the matter to EHS and HR as they should have. You need to remember that even informal or oral complaints can be protected activity under 11C. And you also need to remember that even if you think an employee is being frivolous or spiteful in bringing a safety concern forward, you're setting yourselves up for an 11C claim regardless if you react badly. You know, you also want to thank employees, as we've indicated, when they raise concerns. That's absolutely critical, and it's not always easy, but you need to do it. You need to be responsive and positive. Investigate all health and safety concerns. Consider involving counsel, particularly with serious claims. You often will want to have the attorney-client privilege applicable to the company's investigation. If you have a bad actor, if you have someone who's acted inappropriately with regard to safety or health or reacting to a concern about safety or health, deal with them vigorously and decisively. With the complaining party, who always engage in an ongoing dialogue so they don't bring their 11C claim, as we've discussed. Be cautious about relying on some representation from a plant manager or supervisor. Look, there's nothing to be seen here. Don't worry about that complaint from the employee. Everything's fine. Dig deeper, interview witnesses. These are terrible cases if you get an 11C case. If there's going to be an 11C investigation, prepare witnesses carefully, even though you can't be in with non-supervisors. You should prepare them like you would prepare them for a deposition. Tell them to tell the truth and give them all the other good advice about how to respond to questions. If you get an 11C claim, you'll have to write this very important document, a position statement. You need to do a great job on it. Usually it's pivotal as to who wins and loses. You need to investigate the facts carefully. You should always have counsel internally or externally review any 11C SOP, statement of position. In the document, you emphasize your unwavering commitment to safety and health and non-retaliation. Whatever underlines safety concern led to the retaliation complaint, you talk about what you did to address that, and you emphasize that you encourage people to come forward. You offer a legitimate non-retaliatory explanation for whatever adverse employment action the employee is complaining about. Your SOP has to be top grade. Again, unlike an EOC statement of position, which sometimes is inconsequential, statement of positions in 11C cases are always consequential and have to be done very carefully. I hope you found our presentation helpful today. This is an active time for safety and health, and we hope you all are well and remain healthy. Thank you. Have a great day.